from one expert to another, because a ballistics expert is now expected. That's Mangena, who has contradicted the Cato Manor police version of events before the Nkabinde Inquiry, which is investigating South Gauteng Director of Public Prosecutions Andrew Chauke's fitness to hold office. Mangena says he was brought to KZN in 2012. That was to examine the Cato Manor cases closely. Mangena's ballistic evidence suggests that none of the suspects who were killed had attempted to shoot at the police. Nqobile Madlala, who's joining us now live from Pretoria, has been following proceedings out at that inquiry. A ballistics expert now sharing a contrarian view somewhat, and a view maybe that might not necessarily be shared by many, but an interesting one nonetheless here. Nqobile, good morning.
Good morning, Arabile. Indeed. In fact, as we listen more to what happened in 2012 when Lieutenant Mangena was in KZN, we are understanding that what was on the docket and the dockets that he was looking into were about 6 dockets. But what is shown with regards to the ballistic report is quite concerning. If anything, even Nkabinde Inquiry panel has asked if the family has received the justice with regards to what has taken place in these reports. Now, we have traveled, of course, to various scenes, one of them being the fact that Nqobile was one of the people that we are told was actually arrested by the Cato Manor unit when they were trying to find the taxi boss bar. And we understand that not only was he handcuffed and they took off their handcuff, but he reached out for the gun and then tried to shoot at the police. However, the police then had to defend themselves. That's, of course, what is written on the docket. But what the ballistic expert is saying is that actually, Nqobile was on his knees, that the shots that killed him actually went into his head through here, all the way to the back. And they're saying that there is no way that he could have been able to lodge a gun during that point. We're also taken to another scene, which is on Mangena Road. Mangena Inquiry is the man that you remember went to court. Now, this man had tried to interdict the police, and what he was saying is that he was willing to cooperate if they wanted any information from him. But we are then told by what was on the dockets that the police tried to stop him on Mangena Road. However, he did not stop. Instead, he started shooting through the window. According to the ballistics report, though, the window was closed, which means he couldn't have shot through the window. The gun was on the wrong side of the hand. It did not make sense that he would shoot through the window and it would fall far on the left-hand side. And we are told as well that he was then killed from the back of the car. The killing shot was of a handgun, and it hit him on the back of the neck, which means he couldn't have responded. Also, they argued that there's some details on his elbow that shows that he was actually trying to hold a steering during the time when they killed him. Now, we're told that, of course, all of these allegations has shown based on what the expert is giving us. We then traveled to another case of a 15-year-old who was sleeping, we're told. This is when the Cato Manor units came in to try and find the 2 prisoners that had escaped. As they came in, we are told that they tried to get details, and that's when the 15-year-old pulled a gun and tried to shoot at the police. However, Arabile, ballistic experts are telling us that that's not the case. They're saying, in fact, he was sleeping in a position, looking up, that there was no way that he could have responded by shooting at the police. And all of this is coming from the details that were coming from the 23 docket that were monitored by this ballistic expert. Let's listen in.
In the light of this evidence, with the acquittal, as you state, what could then happen? No attempt to appeal by the prosecution authority? In the light of this evidence, which was not placed before the court, which ought to have been placed before the court?
What we have thought is the case is that it's a case where most probably there was prosecutorial misconduct, where evidence was suppressed, which means that there should be consequences for the prosecutors who ran the case. As far as the family is concerned, we thought that a civil claim for damages would be their only remedy.
Nqobile, of course, as we look into these dockets, there's been a concern from the panel that justice needs to be served to these families. So they've asked questions whether or not the families can be able to continue in light of the evidence that is coming out in this inquiry. That, of course, is part of the conversation that they are now having with Advocate Nqobile, who's part of the legal team from Andrew Chauke. But all of this starting from the fact that there is a suspended South Gauteng Director of Public Prosecutions, and he's being asked whether or not he made any prosecutorial roles, if he did push for the racketeering charge. And based on what we're hearing from the experts is that there was a pattern, and again, speaking to that issue of a racketeering charge and how they got into a racketeering charge with regards to the Cato Manor unit. But we'll hear more details as the Nkabinde Inquiry starts at about 9 o'clock.
9 o'clock it is then, just under 40 minutes to go until proceedings kick off there. Nqobile Madlala following that for us. We'll get more on that story as it kicks off.